Professor Gerald Bamberger. Today, in the spirit of the 4th of July, we're going to work a constitutional law problem. It's going to be a flag desecration problem, in fact. It's problem ConLaw3. You can find it on my website, www.profbamberger.com. If you haven't already worked problem ConLaw3, why not take a moment, pause this presentation, go over to www.profbamberger.com, spend about 1 minute and 45 seconds working problem ConLaw3, and then return and resume this presentation. I'm assuming you've already worked problem ConLaw3 over at my website. The correct answer is choice A. The court will most likely dismiss Darla's suit as unripe for adjudication. Before I go any further, let me just refer you to the case that this problem is based on. The case is Lawson versus Hill. It's a really good case to read. It's a 7th Circuit opinion written by Judge Posner. Very similar facts and an excellent opinion to read. So if you have the time, I'd recommend that you look into Lawson versus Hill. Back to our problem. The correct answer again is that Darla's suit is unripe for adjudication. Therefore, it's going to be dismissed. Why is it unripe for adjudication? Okay, Darla is bringing suit in federal court. Now, under Article 3 of the U.S. Constitution, a federal court can only hear cases and controversies. Cases and controversies involve situations where there is a person who suffered actual harm or who's about to suffer imminent harm. If you don't have a person, a plaintiff, who suffered an actual harm or who's about to suffer an imminent harm, you don't have a case or controversy. Here, Darla hasn't suffered an actual harm, isn't about to suffer an imminent harm. Darla has no case or controversy. The federal court can't hear her case. It's unripe for adjudication. So, why does Darla's case not present, if you will, a case or controversy? The answer is in 2 parts. Part 1, the statute Darla is worried about is unconstitutional as applied to Darla. Part 2, no one has threatened Darla with prosecution. Not the prosecutor, not the chief of police. No one in a position to prosecute Darla has threatened her with prosecution. And since the statute is unconstitutional as applied to Darla, it's not likely to be prosecuted. Therefore, Darla is in no danger of imminent harm. Therefore, no case or controversy, unripe for adjudication, case dismissed. Why is this statute, this flag desecration statute, unconstitutional as applied to Darla? Now, first of all, note I've said as applied to Darla. This statute is not necessarily unconstitutional on its face. You may be able to punish flag desecration. The cases talk about this. Now, if a statute criminalizes, for example, dragging a flag in the mud, and someone drags a flag in the mud, not to make a statement, not for any expressive reason, but because they're tired and the flag is kind of heavy and they drag it in the mud. In that situation, theoretically at least, the person could be prosecuted for under a flag desecration statute. Here, however, Darla is engaging in expressive conduct. That means the First Amendment kicks in. Darla has a First Amendment right here, and that's being interfered with this statute. That's the problem. That's why, as applied to Darla, who is engaged in expressive conduct or symbolic speech, the statute is unconstitutional. Why is Darla engaged in expressive conduct, symbolic speech? How do we know that Darla is engaged in that conduct? The answer is there's a test in Spence versus Washington. The Spence versus Washington test says a person is engaged in expressive conduct or symbolic speech when the actor intends to convey a particularized message and the audience would understand the message based on the conduct. Here, Darla is engaged in expressive conduct, symbolic speech. Darla has painted a peace symbol on a U.S. flag for the purpose of protesting the war in Iraq, and the audience is going to understand that this is a protest. So this is definitely expressive conduct. It enjoys a certain amount of First Amendment protection. The First Amendment is what kicks in to make this statute unconstitutional as applied to Darla. Okay, so Darla is entitled to some amount of First Amendment protection. How much First Amendment protection? Now you've got to realize expressive conduct isn't a license to do just about anything you want. For example, a person might be dissatisfied with the policies of certain government workers in a certain building. Can they go burn down that building as a means of expressing themselves, expressing their dissatisfaction with those policies? You and I both know the answer to that is no. You can't break arbitrary laws simply as a means of expressing yourself. So what is the level of First Amendment protection that's afforded in a situation where there's expressive conduct? Okay. That test comes from United States versus O'Brien. United States versus O'Brien was a draft card burning case. A person burned a draft card as a means of expressing themselves. passed the Spence versus Washington test. The person burning the draft card clearly had the intent of protesting the war in Vietnam, and the audience who watched him burn the draft card clearly could recognize that this was a protest. So it was expressive conduct. Could it be punished under a statute that criminalized the destruction of a draft card? And the United States Supreme Court said yes. The United States Supreme Court said the law that criminalized the destruction of the draft card served an important government purpose unrelated to the suppression of expression. The draft card was an integral part of selective service. It was not merely a symbol. It was part of a system. It was an important part of the business of conducting the selective service system. The person destroying that draft card interfered with the functioning of the selective service system. If you will, it's kind of like burning down a government building. You're interfering with something that's an integral part of the operation of the government, something more than merely a symbol, something that serves a government purpose beyond a mere symbolic purpose. How about flag desecration? How about what Darla has done here, the painting of a peace sign on an American flag? Is that like burning a draft card, or is that something else? And the answer is, under United States versus Eichmann, a flag desecration statute, such as the one Darla is worried about, Darla isn't being prosecuted, such as the one Darla is worried about, a statute that would punish knowingly or intentionally mutilating, defacing, or trampling a United States flag, that doesn't serve any important government purpose unrelated to the suppression of expression. Now be careful about this. It serves an important government purpose. Our flag is a national symbol. It's an important symbol. It's important to have people venerate the flag. But that's purely an expressive purpose. So the flag desecration statute under the United States versus Eichmann, regardless of whether it deals with burning a flag or these other modes of desecrating a flag, the flag desecration statute is all about suppressing certain kinds of bad expressive conduct. So that's why the statute is unconstitutional as applied to Darla. Darla is engaging in expressive conduct. The statute serves no important government purpose independent or unrelated to the suppression of expression. Therefore, the statute's unconstitutional as applied to Darla. Darla hasn't been threatened with prosecution, no threat of imminent harm, no case or controversy, case dismissed as unripe for adjudication. Now let's take a look at the incorrect answers. Choice B says the court should dismiss Darla's suit because it violates the 11th Amendment. The 11th Amendment prevents a person from suing a state in federal court. This situation is what's called an ex parte Young exception. Here Darla is not suing a state. Darla is suing state officers, here a prosecutor and a police chief, in order to enjoin the enforcement of a state statute. That fits within the exception of ex parte Young. No 11th Amendment problem. Choice B is an incorrect answer. Okay, let's take a look at choice C. Choice C says the court will most likely deny Darla's request for injunctive relief because the statute regulates conduct, not expression. It's important to recognize here Darla is engaged in expressive conduct. Therefore, she has First Amendment rights. In order for a statute to be enforceable against Darla, it's got to have an important government purpose unrelated to the suppression of expression. Here, this flag desecration statute, because the flag is a mere symbol under United States versus Eichmann, flag desecration statutes are essentially all about expressive conduct. They don't have an important government purpose independent or unrelated to the suppression of expression. That's why the statute is unconstitutional as applied to Darla's expressive conduct. That's why choice C is the wrong answer. Finally, choice D. Choice D says the court will most likely grant Darla's request for injunctive relief because the statute is unconstitutional on its face. Two reasons why choice D is wrong. First of all, the court won't grant Darla's request for injunctive relief because the court won't reach the merits of Darla's request. The court won't hear Darla's suit. It's unripe for adjudication. Second of all, even if the court were to reach the merits, which it won't, the statute is not necessarily unconstitutional on its face. Remember, it's because Darla is engaged in expressive conduct that she has a First Amendment right, which makes the statute unconstitutional as applied to her. The statute theoretically could be applied to a person not engaged in expressive conduct. That's why choice D is the wrong answer.